with the Environmental Integrity Project, and I am their coordinator of Pennsylvania Community Outreach. And I have been a community advocate for almost 3 decades. I know that's hard for me to even say that. I'm dating myself. But I'm hoping to share with all of you today some of the lessons learned over my journey. And most importantly, as more communities are facing public hearings in the local arena, want to be sure that everybody understands the importance of those hearings and how to get your seat at the table. You'll notice on the screen, I have a quote there.
Oops.
It is part of a quote from a larger,
There you go.
whoops.
You're all good.
Yep. This is a snippet from the larger quote from Shirley Chisholm. This is my favorite quote as a community organizer. And it's important for folks to know that sometimes you won't know when that seat is available to you if you don't do the research in advance. But once you know when that seat is available to you, as Shirley Chisholm said, if they don't give you a seat at the table, bring your own folding chair. So with that in mind, let's talk about how to work to secure your seat at the decision-making table, especially as data centers and the infrastructure that it's likely to support them with more fracking and more gas production plants. It's really important that we all understand how those seats at the table are available, when they're available, and how you can work to get your community into that discussion in a productive way. The first thing that's important about all of this is you must know the playbooks. This is like the Steelers or the Penguins showing up for a game. They wouldn't just show up for a game and wing it. They have a playbook. They know who's doing what and what are the moves and how are they, researching things. Are they researching their opponents, watching game videos, things like that. We have to do something similar. And step one is to know the playbooks that industry and most of the time local government and their solicitors know. And if you're new to this arena, you may not know. So let's talk about those playbooks. The first one, it's my favorite one. It is the backbone of local governance. And in Pennsylvania, we have something called the Pennsylvania Municipalities Planning Code, or it's called MPC for short. That is the governmental backbone for local governance. And I put in a tiny URL there to the larger one. There is a handbook that is put out by the state, and it has different chapters in it. And it talks about land use issues, how the local government sets up their planning commission, their local governing boards, their zoning hearing boards. It's all spelled out, and it makes it a level playing field for all communities. All communities in Pennsylvania follow the MPC, and everything is spelled out, including, most importantly, how public hearings are advertised, how they're conducted, and how the public gets a seat at that table. I'm going to call attention in the MPC. If you look that up, you'll see there are different chapters, but the one that's most important is Article 9. And this is the area in the MPC where they talk about the zoning hearing board and other administrative proceedings. Now, over the years, a number of us have worked with some municipal land use attorneys, and they have all indicated to us that the public hearing portion of the MPC is housed under this Article 9. Even though it says zoning hearing board, it doesn't matter. If the Board of Commissioners, the Board of Supervisors, the council is holding a hearing in your local community, they all follow the rules that are spelled out in Article 9. So it's important to know that, and it's important to familiarize yourself with Article 9. In particular, know the rules for public hearings. There are rules for how they're advertised, how they're conducted, the fact that they don't have to be a one and done in one evening. They can be continued over a series of hearings, over a series of weeks or months. And it's important to know that. And we're going to touch on that as to why that matters, because industry, keep in mind, is always working to speed things up because there's less scrutiny, there's less transparency, and they want to hurry things along. What we want to do is we want to ensure that there is a thoughtful, very specific, fact-based hearing schedule that is followed, because building a robust hearing record is key to everything that we're doing. Secondly, you want to confirm with the municipal solicitor on how the hearings will proceed. In some cases, what we've done is we've helped the local community write a letter to the solicitor once a legal notice has gone out that there's going to be a public hearing. And if you are looking at Article 9, it's very important to cite to the section in Article 9 in the MPC that talks about how the hearings will be held and how that local community members may get an opportunity to seek what's called standing. All of that is spelled out in the MPC, and it's always good to get things in writing, write an email or a letter to the solicitor or the board or both, and ask them, this is what the MPC says for the procedures for the public hearing, and I'm just writing to confirm that you will be following these rules in the same way. And thirdly, and we'll talk about this as this presentation goes on, pay close attention to the legal notices. Get in the habit of reading your local newspaper every day. Look in the legal notices. Those are those ones that are like the really tiny little print in the help wanted section, basically, of the newspaper. There are legal notices that are required under the MPC. They have to be so many of them over so many days to indicate a hearing is being held, the subject of the hearing, and it lets you know that documents, if they are available, where you see those, how you request those. We're going to talk about that specifically too. But of the MPC, lots of good information there, but my focus today will be on Article 9. And I always suggest to folks, if you can do it, print out section Article 9 and have it with you at all times. Put it in a folder, staple it, have it with you in your notebook, because when things are happening, you can refer to it and make sure that the rules are being followed correctly. It's all spelled out, and that's really should be the backbone of everybody's participation. The other rule book, so that's the state rule book that governs local governance. The other rule book are local land use rules. Now, these come in the form of a zoning map, a zoning ordinance, land use ordinance, and also the description, the definitions of each type of land use. And it's really important to be familiar with your local ordinances and your zoning map. And that is because each community that has zoning, and most of the communities do, they spell out what type of land is being used for what type of defined uses. So for example, what's allowed in agriculture, what's allowed in residential, commercial, business park. They will have a definition for each type of land use. They will also have a chart that spells out the types of operations that can be housed within those local zoning districts, they're called. So there'll be a chart and it'll say everything from greenways and conservation areas all the way up to heavy industrial. And it will tell you in which zones they're allowed. And it will also tell you the types of permits that are allowed in there as well. Excuse me. It's very important to know the differences between the three types of local permits. The first one is permitted use, which, in my opinion, nothing that is industrialized, like a oil and gas development, or in this case, data centers, because they are becoming more industrialized and they're introducing industry into another zone. It's my opinion that permitted use should never be the category that these fall under. Permitted use is basically, I like to use the example that, let's say a builder is going to a community to get permission to build 80 homes, and they have a tract of land, and it goes before the zoning hearing board or the commissioners or council, and they hold a hearing and they spell out what they'd like to do. Then there are parameters set, and they get likely a conditional use permit. They get their use, and then when you say you were a landowner that you bought parcel number 11, You would go into the local community and you say, I'm the landowner in parcel 11. The developer already has permission. I'm here for my permit to construct my home. That to me is a good use of permitted use. There's an overarching approval process for the developer overall, but individually, the landowners get a permit to use their land as it's been already designed by the developer. What's dangerous if oil and gas or data centers or something industrial like that is listed in local ordinances as permitted use, that means that there will not be a mandatory public hearing process. So the public will not be heard. The applicant shows up, fills out the proper paperwork, and they get their permit. That's it. And that's what's dangerous, in my opinion, because especially with new types of developments, data centers or gas plants in areas, of course, that have never had them before, it's really important that all voices are heard. And if there is no public hearing, then that takes away that opportunity for local government to ask questions and place conditions, which they're allowed to do, on the operation, and or it takes away the public's participation. So the next two categories are better options because they both carry with them required public participation in the form of a public hearing. Conditional use is something that is usually handled by the local governmental body. So it's the council, the commissioners, the board of supervisors, whatever your township or borough has, they oversee the conditional use process. Again, everything is spelled out in the MPC. But most importantly, it gives the public the opportunity to be heard. It also gives the applicant a chance to be heard. And it also, very importantly, which we're going to talk about coming up, it gives the public, those who are given what's called party status or objector status, it gives them the opportunity to actually cross-examine any of the experts that the applicant brings forward. And that is something I didn't know when I started, and a lot of people who are new to this don't know that. That is key. We're going to talk about that in more detail as it goes. Special exception is typically when an applicant is looking to build something, like say a gas well pad or a data center, in an area that's not zoned. It's not a zoning district that allows it. So they're basically seeking a special exception to be allowed to break that rule and put their operation in an area that previously was not zoned for that. That special exception is typically carried out by the zoning hearing board. And for local governance, or the voting bodies, they meet once a month. Zoning hearing board is different. They, in most instances, unless you're like the city of Pittsburgh, where they have a lot of things going on and they meet more regularly, local zoning hearing boards usually meet either quarterly or they meet on an as-needed basis, as an application comes in and there's a need for a special exception hearing. So it's important to watch, maybe have a team plan to go to the planning commission meetings where sometimes new projects are discussed. Have them attend the board of supervisors, commissioners, or council meetings because that keeps you in lockstep with what's being discussed. And then also keep a very close watch for those legal notices, especially for zoning hearing board, because if there's something going before the zoning hearing board, there may not be a regular meeting that you can follow. That's going to show up in the legal notices. Public hearings are a very important cornerstone. It's a building block. And what you will see as this presentation unfolds is that having the opportunity to get as many facts on the record is key to not only helping the local government make an informed decision, it helps the public have a seat at the table, and it also prepares the foundation should there be a reason to appeal a decision. And that's something that I will mention, that any decision that is made by local government, there is a 30-day window in which the citizens and or their experts or their attorneys can file an appeal to that, and they can challenge that. But it's important to remember as you see these next few slides, if you don't have a robust hearing record where lots of information, lots of questions, and lots of testimony was provided, it will not help you in the appeal process, because if and when a decision is challenged and it goes to an appeal, it usually starts at the the respective county's court of common plea. And whatever judge is assigned that, they're only going to be able to watch and learn and look at the four corners of the hearing record. So if something wasn't on the record, that judge will not be able to consider it. And at the end, I'll tell you some success stories of communities who did just that, and they were able to use that record to get a judge to take a second look at the decision. So let's talk about what are the different pieces that go into preparing for the public hearing. So as I've mentioned a couple times, the legal notice is key. You're watching that newspaper every day because those things may appear seemingly, excuse me, out of nowhere. But if you're watching the legal notice, that's a real big hint as to something that is coming your way. Secondly, the application documents, if you're going to the planning commission meeting or you're attending the voting meetings of your local governmental board or commission, you will know if there's an application being discussed or that there's an applicant there saying we're about to apply. You're listening. You want to be the eyes and ears for your community. You want to be listening. Once you know that application documents have been submitted, you want to file a right to know request to get all of those documents, because it's very important. Step 3 is to be prepared in advance. You do not want to be reading the application the night before hearing. It will not help you. They are very technical, they're very involved, they're very voluminous, and it's really important to know what's in the application document. Know the applicant, because if that applicant has shown up in a neighboring community or somewhere else in the state, there may be a record of experts they called, things that they said, information that they shared that will be helpful to you in your community. And number 5, using that information, particularly if you know that that same applicant has showed up at 1 or 2 other communities, talk to people in those communities, reach out to them, try to get file a right to know to get information about what was presented by the applicant, which witnesses they called. It's very important because you then might be able to find out if they're going to call the witness on a particular subject. You might be able to do a little bit of a research project on that expert, prepare cross-examination questions, and also prepare what's called your case in chief. It's really important, and we're going to dive into each of those sections as we go, but this sort of sums it up. It's very important to be prepared, and the more advance notice you have, the better it is for you and your community. And I always tell people, especially where new types of applications are concerned, data centers, gas plants, things like that, local government may be just as overwhelmed as you feel. And we don't want to go in, tar and feather them. We want to go in and try to create an opportunity for us, the community members, to be fact finders on their behalf, or to be folks who can be counted on to do the research and present factual information. We want to become a factual resource for the decision makers. We don't have to be best friends with them. In fact, if there's a hearing going on, you're not allowed to have communications with them about the hearing subject. It all has to happen in the open forum for everyone to hear. But it's important that you set yourselves up as the reliable fact presenters. And that will help those on the board or the commission who may be learning these things too. Being able to show them something in writing, give them a fact to point to, will help them in their process of maybe learning with an objective eye. We don't always get that. I understand sometimes people have a favorite way they want to go on something, but on the whole, local governance is supposed to be objective during the hearing process. So you've heard me say it, to establish a robust public hearing record. So how do we do that? What are the steps to do that? And how do we learn and teach each other how to do that? So here are 4 key things that you've probably heard me mention, but let's dive into them individually to talk about this. So there are 4 ways in which the public can comment or participate in the public hearing. And I have to tell you, I didn't know this when I first started out. I didn't know this. I learned this through trial and error for, being in public hearings, reading the MPC, and learning as we go. But the 4 ways in which people can participate in a public hearing include these 4 items. First of all, party status. And what is that? So when a local government holds a public hearing, there is supposed to be, on the first night of the hearing, there's supposed to be what I call the housekeeping portion of the hearing, in which the solicitor reads the notice, describes why we're all here tonight, what are the parameters of the hearing. And they're supposed to offer the opportunity for folks who live within a certain prescribed boundary, and the local community can set this distance. What is the impact zone, basically? And the folks who live in that impact zone are supposed to be given party or objector status. And what that means is really important. It means that it provides unique participation opportunities outside of just the stand up, like we're all used to, stand up and talk for 3 minutes and sit down. This has very unique opportunities. It gives you the opportunity to cross-examine any witnesses that the applicant brings. It also places no time limit on you. You can ask your questions within reason. You can't be stalling, but you can go through a process where you're asking questions of the applicant. You're familiar. Remember, we're very familiar with the application. We've done our homework. We've researched the applicant. We've researched other communities in which they have made similar proposals, but we want to create an opportunity where more information is made public, made transparent. The only way to do that is for folks in the community to seek and receive party or objector status. Secondly, that cross-examination it's not going to be for everyone. It's only going to be for those who get the party or the objector status. And that's okay. If typically it's a handful of people, because sometimes they'll try to limit it to a half a mile from the proposed project. Some communities have gone a mile or a mile and a half. It depends on the solicitor. The solicitor typically functions as the hearing officer, and he or she may have a little bit more grace as far as how far they will allow the geographic radius from the proposed project. But it's really important because in that cross-examination, you're given an opportunity to get important information on the record. Did their expert contradict themselves? Did the expert not have an answer to the question? Did you find something out that wasn't spelled out in the application, but upon questioning, you got more information? Remember, we're building the cornerstone and the foundation of that robust hearing record. The third way in which folks can and are allowed to participate in the public hearing is their case in chief. This also goes uniquely to those who have been granted party or objector status. So the way that it's supposed to work, the applicant usually does a presentation. They present technical documents. They put things on the record. They must give the opposing side copies of that information. Sometimes they'll give it to you hard copy, sometimes they'll give it to you on a thumb drive. But if you have party status, they're supposed to provide a copy for you and the township or the borough. And they go through their presentation for each of their experts. And then those who have party or objector status individually get to provide cross-examination questions of those experts. So it goes back and forth. The applicant presents, the cross-examination questions happen. The next expert, same thing, they present, and then cross-examination happens from those with party or objector status. That happens throughout all of the applicant's presentation in their case in chief. Then it switches. And then those who have party or objector status present their case in chief. They can call witnesses, they can call experts, they present their facts, and again, opposing counsel gets to cross-examine those experts or those witnesses as well. Goes back and forth just like it did in the first part where the applicant was presenting. Each person who's granted party status has the opportunity to present their case in chief. It's important that you don't duplicate. You have to work as a team, divide up the workload, and say, okay, person A is going to talk about land use issues. Person B is going to talk about property values diminishing. Person C is going to talk about health and human safety. You want to divide up the workload so that you're not being repetitive, but you're hitting the key factors that you would want a judge in the future to know what was said, what was put on the record, and why. And the last part of the public participation comes in the form of the general public comments. Anyone from anywhere can present during that portion of the hearing. It is a public hearing. That is the portion usually where the solicitor will say everyone has an opportunity to share 3 minutes of their thoughts. And that is where that public participation component fills out those missing pieces for those maybe who didn't have party status. But it is important to know that that is just a very small section of all of the pieces, excuse me, that go into creating that hearing record. And I will say that sadly, I have been at some so-called public hearings where the solicitor missed those 3 previous steps and they just went to, okay, just give us your public comments. That is not the correct way, in my opinion, and based on the MPC. And I think that's all the more reason that you need to be familiar with what are the rules for public hearings. And you can then get that in writing. Is it going to follow all of these steps as spelled out in the MPC? You don't want to get to a public hearing and be surprised if the solicitor has gotten it wrong and they've skipped those other 3 portions of public participation. So very important that you understand the rules you get for something confirmed in writing and be prepared when that day of the public hearing begins. This is key. You must get ready and be ready on day 1 of the hearing. Industry, as I said previously, likes to move quickly. They want to do what I call a one and done hearing. They want to get there, make their presentation, take a few public comments, boom, they're done, and they hope to get their permit. We want our teams to have all of their homework done in advance and be aware that it is not necessary that a hearing conclude in one night. That's a misnomer. There are some folks who think that there's only one night, the hearing opens and closes in one night. That is not true. The MPC spells out once an application is received, how many days lapse before they hold the first public hearing. It has to commence within so many days. And then as long as the hearing officer, typically the solicitor, does not close the hearing, they can do what's called continue the hearing. The hearing can start, and I'll give you an example in Ross Traver. You'll hear me talk about that later. It was almost 12 months of hearings. It was before the zoning hearing board. It was for a proposed well pad under special exception. It was in an agriculture area, and they wanted to put a well pad. And many of us participated. We started in our winter coats. We went through the spring and the summer and back in our winter coats when it finally concluded. But the zoning hearing board continued that for about 10 or 11 months. And that is the proper way to do it so that everyone gets heard. There's enough time for experts to be called. There's enough time for cross-examination. And most importantly, there's enough time for case in chief for the party or objector status folks. So we want to make sure that you have all your homework done. You've done your research. You have gotten confirmation from the solicitor in writing how the hearing will unfold. And you are prepared the first night that they open the hearing to seek party status, if they move that quickly, be ready to offer cross-examination questions of the applicant and be ready for your case in chief. Now, I know that sounds like a lot, but there are a number of groups, including Protect PT and others, who have done this for years. Reach out, buddy up with communities who've done this before. And there are folks, our group has done it. A number of groups have lived through these things before. Don't reinvent the wheel. As soon as you find out something's happening, partner up with other community members, other community teams, partner organizations, advocates, and get help. Don't try to go it alone, but try to share the information. And we're trying to pass this information along from one community to the next. So be ready on day one. You may not have to be starting down that path, but what you don't want to have happen, and this has happened. Industry says we're ready to go tonight. They put on a very brief presentation, and then the burden shifts over to the objectors, and they're not ready. If you're not ready, they'll conclude the hearing and you won't get that opportunity. So very important, quickly do your homework, quickly reach out for help from other partner groups, and be ready on day one. Fact-finding is the key to being prepared, as you can well imagine, as we've talked. So how do you do that? What are the mechanisms by which you can do efficient fact-finding? First, as I mentioned, you want to research the applicant and the documents that they've submitted to your community. You can, in Pennsylvania, submit what's called a right to know request. It's the state version of the federal, which is called a FOIA. You may have heard of that, Freedom of Information Act request. That is reserved for federal requests. In Pennsylvania, it's a state right to know request. There's two forms. There's an informal file review, and there's a right to know request. You can find those on the DEP's website. You can Google Pennsylvania right to know request, and it will walk you through. The Office of Open Records is amazing. They have a lot of resources. What constitutes a public record? If something's withheld, what do I do? But you want to submit your right to know request to the township or borough. You can use the standard Pennsylvania right to know form. It's self-explanatory. You spell out what you want to receive and you request it. Put everything in writing. It has to be on a form. Otherwise, they may not honor it. You do need to know that when you file a right to know request, they will either approve your right to know right away, deny your right to know, or most cases, they'll ask for an additional 30 days to fulfill your right to know. So again, if time is of the essence, you want to be making these requests maybe in an ongoing fashion. If you've heard rumors that a company is planning to come to your community, you might want to start, every 2 weeks submitting a right to know request so that you're keeping pace with something that may be happening before it actually hits that legal notice. You want to understand the procedure. You want to make sure that you understand all the procedures. Is this a conditional use hearing? And what does that entail based on the MPC? Is it a special exception? What does that entail? How do you familiarize yourself with those procedures? Be familiar, as I said, with local zoning. Even if you're listening and you don't have anything coming to your community today, that's fine. That's great, in fact. But do your homework now. Be familiar with your zoning map, your zoning districts, what's allowed in each district, and the definition for each district. What legally the community will allow in the development of commercial park or business park or industrial, light industrial. You should be familiarizing yourself with that right now, even if there isn't anything coming your way yet. Understand the public hearing procedures. Very important, as I've spelled out, that you know what's required. You get in writing the way they're going to do it. And if need be, cite to the MPC because it spells out under Article 9 how those notices and hearings are supposed to happen. And then, of course, key to all of this is asking and hopefully receiving party or objector status, because as you can see, gives you more time to seek transparency, more time to build that robust hearing record, and it gives you multiple bites at the apple. You get to cross-examine and you get to do your case in chief Call experts. That's important because, again, more information on the record is always better. Can't say this enough. Start your research today. If you are listening to this, start reading the MPC. Start looking at your local zoning map. Go to, their website, and if it's not listed there, ask them if you can get a copy of their zoning districts, their map, the definitions. Start doing that homework now, because if something happens, you don't want to be bogged down doing the basic research. You want to be stepping into step 2, which is understanding the application. One key thing I will tell you, this Act 14 notices, this is the tip of the spear. When a project is being contemplated and it's going to involve some permitting from the state, which data centers will be required to have air permits, hopefully. They have to provide, if they applied for something to the Pennsylvania DEP, Department of Environmental Protection, they need to also notice the host municipality, the host county, and the adjacent counties. And the adjacent municipalities, so that if something is going in and it's going to impact that area, the applicant has to notify the host municipality in particular, in the host county. We've applied to the state to develop an XYZ project, and you, the local municipality, has 30 days to comment to the state. That's a really good way to find out if something is being talked about in the planning stages, and you get in lockstep with what's going on. So the Act 14 notice letters will come in as a certified letter, something that the municipality has to sign for. That's the first signal, and those are all public. So if you wanted to put in a standing request, every month you ask for all of the Act 14 notice letters that the borough or township has received. We actually have some communities in Washington County that have stepped up in a big way. They print them out and bring them to the local township or borough meetings, and they provide them to the public. So having a snapshot of something that's being applied for at the state will also give you an opportunity to learn more about the project, maybe before the application hits the desk of the local municipality. As I mentioned, file your right to know requests, and you can file those to the state. You can also file those to local government. You can use the same form, doesn't matter. It's a state form. You'll find it on the website of Office of Open Records, or if you just Google Pennsylvania Right to Know form, you'll find it. This is key. You want to review those materials in advance of the hearing. You want to use the materials to create cross-examination questions. Like, for example, if the applicant hasn't talked about maybe a traffic study, you might ask them in your cross-examination, I see in your application, traffic study is missing. And if it's required in the municipality, you might point that out and say, when might we expect the traffic study? But you wouldn't know to ask for something specific like a traffic study or something else that's required in the land use ordinance if you haven't done your homework and you haven't read the materials in advance. Those materials will provide you nuggets of information that can be the basis on which you create the cross-examination questions, which unlock some of the transparency issues. And finally, if you can, find experts, legal and scientific, if possible. Now, our organization, the Environmental Integrity Project, has a division called the Center for Applied Environmental Science, CASE, C-A-E-S. And we provide technical experts for low cost. We provide small grants to community members, and we've done this in the 2 examples that you'll see coming up, where we had a sound engineer or we had a mechanical engineer review the application, and they became an expert that the party objector status folks called as witnesses. So if you can, and if you have time, start networking to find experts. And if you have the resources, maybe for community members to pool together and hire an attorney to either go with you to the public hearings or help you if you decide that you want to appeal a decision that's made down the line. I always say this, my two favorite things is bring the folding chair, like Shirley Chisholm said. If they don't give you a seat at the table, bring your own folding chair. And also, facts are the great leveler. They provide insight to what's happening. They provide the basis for more transparency and more thoughtful review and questioning. So, with that in mind, I want to tell you two short things that will maybe provide some hope. I admit, and I've been doing this, as I said, a long time, the work is hard and it seems unending at times. It seems overwhelming at times. However, there have been some communities who have achieved some level of success, and it was based on the fact that they had robust hearing records. The first one, and you may have heard about this, but Protect Elizabeth Township, Protect ET, they had it was a company that wanted to put a well pad next to their high school. We all participated in the public hearings, which took, I think, 3 months, three different hearings. And the Protect ET team brought over two experts from our division called CASE, a sound engineer, mechanical engineer. They were brought in as witnesses and experts, and they provided information on the record. And then the Protect ET team did an amazing job. They did their homework. They found out experts that have been called by the same company. They had very detailed cross-examination questions. They got all of that on the record, including the fact that there were about 30 violations of the local land use ordinances that the company did not abide by. And the Protect ET team asked that the township deny the permit. The township did not. The township approved the permit and it went to an appeal. And it has gone all the way through the Allegheny County Court of Common Plea. They hired an expert land use municipal attorney by the name of John Smith. He is amazing. And he represented them in the Court of Common Plea. And then it actually went up to the Commonwealth Court. And it was at the Commonwealth Court where the judges, and I believe it was the entire bank of judges, that said that the township had in fact violated their own ordinance. And they said the conditional use permit that was granted by Elizabeth Township was null and void. That was the Pennsylvania Commonwealth Court that said that. Now, unfortunately, the well pad has been built and the interconnect has been built, but they're still going through the legal process to see what else they can do to push back on that. But the only reason why the Commonwealth Court was able to fully understand and see all the documents that were part of it and see that the township had misstepped was because of that very robust hearing record that over several months the Protect ET team created. The second one you heard me mention earlier in Ross Traver Township, about 10 months of hearings in which the applicant did their presentation. The community members were amazing. They did a great job researching. They, as nervous as they were, and I know that it is nerve-wracking to do this, they cross-examined those witnesses. They got a lot of information on the record. And they also hired a sound engineer from our CASE program, and he pointed out where this particular well pad would have violated their sound ordinance. So after about 10 months of hearing, a decision came down and the permit was denied. And it was challenged by the company. It went to Westmoreland County Court of Common Plea, and a judge that has never really done anything in favor of the community members where it came to oil and gas, he upheld the denial. And the reason why he upheld the denial was because the hearing transcript showed clearly that the township had not upheld or had upheld their local ordinances by denying it. And he said, based on that, he ruled in favor of the denial standing. That application was ultimately withdrawn. So you can see it is tedious. I will not kid you. It's a lot of stress, but there are many of us who've been through it before, and we would be happy to come alongside and help where we can. But we all have to be helping each other because communities are basically facing challenges every day. It seems like a new application for something is popping up. And I think we have to just be our own best helpers. And there are enough of us out here now that we can band together. Don't reinvent the wheel, as I said, but know these are the basics to get you started. And then let's network. Whoops, sorry. I do want to say that communities can make a difference, and it does take a village and many villages in this case to help each other. So let's work together, let's share information and share expertise and experiences because we are all in this together and we can make a big difference if we get our facts, we get things in writing, we seek transparency and accountability, and we build those robust hearing transcripts. I really appreciate this opportunity. If you have any follow-up questions or you want some more information or ideas on how to network with other folks, my email is there. Happy to be part of any continuing discussions because I think we're going to be seeing more and more of this, but the better prepared we are now, the better our communities will be in the future. So thank you so much for your participation.
There we go. Sorry, I was muted for a moment. Lisa, thank you so much. I
No worries.
appreciate that. You held strong there, sitting there, with no sound. Appreciated. Anyway, thank you so much. That was amazing. This presentation is going to be available on our YouTube, and sometimes we'll go through and grab some clips and post those on our social media as well. So, if anyone is interested or if anyone has any questions, please feel free to ask them in the chat. I see you guys popping in there. Yeah, of course. Thank you so much for joining us today, guys. Yeah, I really appreciate you guys coming in and engaging and watching with us. This was really awesome. We had a few people reaching out over the past couple weeks with the work we've been doing in Upper Borough, as well as Springdale with the data centers of just how to get involved and how they can empower themselves. So this was a great crash course. To plug Protect PT a little bit, we have a Living Near Shale Gas Community Workshop coming up in September. So if you are interested in similar work related around oil and gas, also very helpful in how to bring yourself into these local meetings as well. And are the associated slides available? That is a good question. I have them. Lisa, do you mind if I share these or put a link to these in the description?
Absolutely. Feel free to share. We're like I said, we're all in it together. So yes, feel free to share.
Yeah, you can expect this YouTube video to be updated by the end of the day with links to more information on our website, a link to some information about Lisa, and the slides as well. So you can expect that here shortly. Thank you guys for joining us. Everyone have a wonderful day.
Thank you, everybody.
Bye, guys.